Okay, thank you, Brian, and welcome everybody to the third of our panels in this one-day symposium on law and literature. We have 4 presenters. Each will speak for about 14 minutes, no longer, please. They are, in order of appearance, Susanna Blumenthal from the University of Minnesota, Braden Cormack from Princeton, Simon Stern from the University of Toronto, and Rebecca Tushnet from Harvard. So without more ado, Susanna, you have your slides ready to go, so let's hit it.
Okay, thank you, Chris, and thank you, Brian, for this wonderful occasion to come together. I am a scholar and a historian of law, and I will say that I've always regarded literature as part of the intellectual and cultural world I'm endeavoring to reconstruct and comprehend. And I've also tried in my work to historicize the relations between law, literature, and science as ways of knowing. My current book project, titled The Apprehension of Fraud in Modern America, approaches fiction as an archive, one that I've been mining with great profit as I explore the constitutive role of law in policing the ambiguous borderlands between capitalism and crime, and more fundamentally, that between truth and its opposites. And like much of the historical work on the subject, it's a project that's certainly haunted by Melville's confidence man. Though I would add immediately that I emphatically dissent from those who have seen and characterized con men and capitalists as two sides of the same coin. I don't think it's quite as straightforward as that, especially when you attend to the legalities of the matter. This symposium comes at just the right time for me, as I am presently wrestling with a range of methodological problems arising from the fact that fiction figures so prominently in this project as a theme, a problem, and of course, a primary source. Much of the action of the apprehension of fraud takes place in the peculiar performance space that was the 19th century courtroom, a space that was often cast in the time and certainly in the historiography as a world apart. Thinking here about Agnew's work, a world apart from theater and the market, even as it partook of both. And I treat trials in my work, especially trials of fraudsters, as stages on which legal actors played out the problematics of personhood, not least because the most spectacular ones were those that were turned into theatrical productions after the fact. As I reconstruct the performances of trial participants, I am especially interested in their ways of thinking in cases, to borrow the title of John Forrester's book by the same name. More specifically, I aim to compare and contrast the case methods of lawyers, doctors, imaginative writers, and historians, as they have worked to distinguish capitalists from con men and madmen in a boom and bust economy, one in which speculative mania was a common affliction. My remarks today will center on one trial in particular, the spectacular 1856 forgery trial of the Wall Street broker Charles B. Huntington, during which the case of Hamlet was also litigated. In what follows, I'll begin with the briefest of outlines of the trial. Then I'll try to place it in some degree of cultural context, drawing particular attention to the ways that Hamlet and his psychology were portrayed, anatomized, and burlesqued during the period under consideration, both in print and on stage. Then I'll return to the scene of the courtroom finally to examine these citations of Hamlet as they were made by opposing counselors in their elaborate disputations about the culpability of this alleged forger. My aim here will be to explore the play in the law in the double sense, tending not only to the textual appearances of Hamlet during the trial of Huntington, but also to the ways in which law contributes to the making and unmaking of humankind. So here I'm riffing a bit on Ian Hacking's work. They do this in and through the adjudication of individual cases, both fictional and real. So with respect to the case of Huntington, what I observed is that it quickly became the talk of the town after he was arrested in early 1856. You can see some news clippings to that effect. This was owing to the scale and scope of his financial exploits and the failure of any financier to come forward and admit to being among the duped. As one reporter put it, as you see here on the screen, the shavers are shaved at this time. Who are they? Don't all speak at once. In the interest of time, I will gloss over the details of this fraudulent scheme, but suffice it to say that Huntington made a lot of money by obviously forging promissory notes, ones that didn't even pretend to be imitations, as it was said. They were used as security on very large loans, and these transactions were pretty clearly usurious, which explains in part why so many of his defrauded associates kept mum. Yet a significant number did come forward, and the trial on the first of 27 indictments proceeded. This is one that was charging him with $6,500 in the form of a promissory note that was forged. This trial took place in late December of 1856. The district attorney's opening argument cast the defendant's offense in the darkest of terms. It was described as the worst, the meanest, the most despicable of all commercial lies which a man can tell or a man can make, a black lie and a white lie at the same time. He waxed hyperbolic about how wide awake these forgeries were, and inadvertently in the process, in his bluster, referred to it as a sort of moral insanity that seemed to have seized upon him. And without pausing to consider the exculpatory effects of his own portrayal of the prisoner, he kind of built up expectations by promising jurors that they would they were really in for quite a show. As he put it, you may pile your bookcases with novels and dramas, but you will never find them as interesting as the transactions that pass before you in this courtroom. What followed was kind of a snooze. It was very tedious testimony that did leave almost no doubt of Huntington's guilt. The press reported a collapse in public curiosity. The defense would soon have spectators on the edge of their seat once again as the junior counsel, John Bryan, comes forward with a rather spectacular admission. He admits that these notes were in fact forged by his client. But he proceeds to argue that the sheer stupidity, cupidity, and audacity of the crime amount to evidence that he must have been morally insane, that he had a, quote, monomania for forgery, which irresistibly impelled him to commit the offense, such that the act is not his own. At this point, he sort of takes a leaf from Shakespeare, and that leaf is from Act 5, Scene 2, as you see it on your screen, which he used this scene in which the Danish prince does a bit of self-diagnosis, and that is quoted to exculpate the defendant Huntington. And sort of the idea that the madness has taken over and become, in fact, the sort of perpetrator of the crime is something that he uses to affect somewhat good effect here. But it does end up being a losing argument or a losing rhetorical strategy in the context of the trial. And that's because of the surrounding context of literary criticism at the time that the prosecutor seizes upon. The sort of dominant or the weight of critical opinion at the time was that this case of Hamlet was one of simulated lunacy. So he sort of summons up textual evidence to that effect, going to show that he was feigning insanity, and by implication, so too is at least the defense attorney, if not Huntington himself. Huntington maintains complete and utter sort of impassivity throughout all this. At one point, he sort of indicates that he's unwilling to be called morally insane, but otherwise says relatively little. And it's worth adding that criminal trials at this point do not allow the defendant to testify, so he had really no choice in that regard. The way that the defense gets sort of pummeled by this sort of sort of reference to Hamlet is that the prosecution, as it's closing the case, basically loads on all sorts of forms of sort of abuse on the defense for bringing forward this insanity dodge. They suffer by comparison with the move in Hamlet itself, because unlike Hamlet, who is trying to expose the conscience of the king, they're in fact covering the worst criminal offense imaginable in a commercial community. And the defense's witnesses hardly come off much better. They were subject to withering cross-examination, during which the prosecutors openly mocked them as dupes who failed to see that the great forger was only playing the part of a madman. As a matter of law, the presiding judge effectively ruled out the defense's theory of the case by defining legal insanity in narrow cognitive terms as a total want of capacity to understand the wrongfulness of his conduct. So instructed, the jury returned a verdict of guilty, and he was sentenced to the maximum 5-year term in Sing Sing, an outcome that most newspaper editors hailed with the, quote, hope that his case gives quietus to the insolent dodge of moral insanity. This hope, however, was disappointed in both the short and longer term. In the immediate wake of the verdict, there was a series of popular representations of this. There was most immediately a serialized version of the trial. You can see here, I hope, Huntington or Modern Insanity, A Tale of Forgery and Fashion, Stranger Than Fiction, the most exciting, the most interesting. It really sort of puffs it up as something worth going to see, worth reading, and so much so that there is then a stage production of it that is attempted, that by all accounts was as lamentable a failure as the defendant's plea of moral insanity, according to the not very good reviews of it. For their part, the attorneys in the case also sort of had something to say after this trial. While they didn't appeal the verdict, they did take the case to the public, to the realm or the court of public opinion. They published a full transcript of the proceedings. This is why I know so much about the trial. While there's plenty of newspaper coverage of it, this is a full transcript of the trial and presented as such. 500 pages in length, with, as you can see here, testimonials at the beginning to the accuracy of the work, and they claim that they're commemorating their defeat for the sake of science. That's kind of their presentation of it. That said, it is one that is very much slanted. It's sort of peppered with footnotes in which they have included excerpts from newspaper articles that figure them well, or figure them in a way that allows them to martyr themselves. And they also sort of draw reference to both legal and medical writing about Shakespeare and Hamlet in particular that show us that the jury was still very much out on the vexed question of whether Hamlet's madness was real or feigned. There are arguments on both sides, as they say. In addition, there was actually an entirely separate appendix that contained patient case histories that were offered to prove the existence of moral insanity beyond a reasonable doubt. So while purporting to hold a mirror up to the trial, this trial of Charles Huntington was a reenactment of a reenactment, I would argue, one that dramatized the difficulty of representing madness and fixing responsibility both within and beyond the courtroom. To appreciate the broader cultural significance, I don't have very much time here, so I'm going to just gesture towards a number of different contexts. As a historian, I can think of a number of different ways to frame this and to understand it in broader cultural terms. One line of historiography that sort of could be referenced with respect to this trial to help illuminate it is the history and historiography of capitalism. The kinds of things that I would point out here are, number one, that it's sort of the Panic of 1857 is just around the corner. It will hit just as Melville's Confidence Man is hitting the press as well, to anything but rave reviews, constituting itself a kind of literary flop that sent Melville into both a mental and an economic tailspin. There was broader ambivalence about the money-getting mania at the same time, and the lawyers in this case very much registered that, and more particularly felt the need to wax moralistic about the ways of Wall Street. For the prosecution, they viewed Huntington as a vulgar forger, whereas the gentlemen of Wall Street had more acceptable ways of making money. But the defense attorneys presented their client, of course, as mentally incompetent, and said that he had business associates that were working behind the scenes to pull the strings, and so he was kind of their fall guy. It's worth adding here that the attorneys on both sides were involved in off-scene, behind the scenes, or in another venue, civil litigation, as they sort of fought over the ill-gotten gains that were being litigated in both settings. All the while, New York does have usury laws that are on the books, and they do have criminal penalties attached to them. New York is one of the most stringent states as far as usury is concerned. So that's one whole context one might introduce to think about this. The other one, and the one that I sort of want to foreground in the remaining time I have, is that with respect to sort of the literary criticism surrounding Shakespeare. It's worth noting here that Shakespeare is, of course, extremely popular in the 19th century. There were several stagings of Shakespeare's Hamlet going on as Huntington was being tried, and the interpretations of Shakespeare's Hamlet varied on the stage. Booth was probably the most famous rendition of it, and he very much embraced a notion of Hamlet as a responsible agent. That's the way Lawrence Levine says, in general, Hamlet was staged in the 19th century. It reaffirmed bourgeois ideas of self-made manhood. Lawyers, for the most part, also subscribed to that view of Hamlet in their writing. Lawyer critics, by the way, were among the most prominent writing about Shakespeare in the 19th century. And they recognized that Hamlet might have had some sort of failure of nerve, but they certainly were not willing to go so far as to suggest that he was insane. He was clearly feigning. But it was this new sort of body of medical men who were specializing in the diagnosis and treatment of insanity, who came forward with this new interpretation of Hamlet. They have Hamlets all over the place in their asylums who behave just like Hamlet does. Just because he says he's not insane doesn't mean he actually isn't insane. He may be feigning insanity and have the wrong diagnosis of himself, but he is still insane. We have all sorts of patients like that, they say. And they also use this as an opportunity to critique the common law. So this whole body of literary criticism that I hear represented with a number of different, this is for Planck's in the middle, and then there are these alienists like Kellogg, as well as there's another delicious example of alienists who wax poetic about Shakespeare and use it as a basis for presenting their knowledge. In Hard Cash, Charles Reade's novel, there's an alienist who is a monomaniac on the subject of Shakespeare and Hamlet's madness in particular, who kind of loses it over the question of whether Hamlet is insane. So there's a lot going on in terms of interpretations of Shakespeare, and the stakes of that interpretation are in terms of both medical authority and broader questions about agency and responsibility. As I read them, what intrigues me most of all is the extent to which the lawyer critics reject this interpretation of Hamlet that the alienists offer because, quote, diagnosing madness kills the tragedy. That to me is an especially intriguing reason for rejecting it. But at any rate, I want to briefly now return before I conclude to the case itself, the case of Huntington, that is, and ask the question, what was Hamlet to Huntington, and more particularly to the lawyers in the case? And what I would say here is that for the defense, I think in the first instance, it was a rookie mistake on the part of Brian. I think he used it as a kind of flourish, an ornament that was intended to make him sort of seem like he was a eloquent advocate, and it backfired. And I think Brady, his senior counsel, who was a veteran trial attorney, was quite embarrassed by it. He wanted to take it back at the end of the opinion. At the end of the whole trial, there's a kind of process in which they were correcting the record, and he wanted to take the Hamlet reference out. He was sort of joking, but not really. In any event, the sort of upshot of this use of Hamlet to buttress the idea of moral insanity failed in the immediate context, but I want to emphasize that the longer term effects of that invocation of moral insanity are much more complicated, and moral insanity continued to have a life in the mid-century medical and legal discourse before it was sort of retired because of its embarrassments, but it reasserted its force in new forms at the end of the 19th century, most notably in the degeneration theory that sort of took hold and Lombroso's notion of the born criminal. So I think both sort of moral insanity and Hamlet, moral insanity lives on, and finally I would say that Hamlet also lives on as a kind of sort of ambiguous character, and invoking Hamlet in any kind of legal case is bound to be somewhat disruptive. The final piece of evidence of that I will present you with is that Hamlet, as it was restaged as a mock trial in 1904 at Yale Law School, played to a hung jury. And we know that Hamlet continues to have a certain kind of force within legal culture. These mock trials have been staged many times since. But as I step back from the case itself and think about the play in law, I guess what I want to conclude with here for purposes of this conversation is that these lawyers, as they invoked Hamlet in the context of this trial, I think ultimately, as much as they were trying to contain the ill effects of their own histrionics, I think we're ultimately most successful in exposing the ambiguity between acting and being a sane, honest, and trustworthy person. And their presentation and exhibition of this kind of play in the law, I think had some disturbing effects on the ways in which lawyers were viewed in this money-making culture, because they only widened the disputable territory between capitalism and crime, and also implicated the law insofar as it was represented as a negotiable instrument, part and parcel of a legal system that could be gamed. Perhaps to his credit, at the end of all of this trial about his state of mind, he pronounced the proceeding a splendid farce. While his attorney said this was just the insanity talking, we can sort of, in any event, sort of recognize, I think, the extent to which litigating fraud is a funny business, but one that we consider laughable at our peril. I think particularly in this moment, we have to recognize the extent to which the law's players pose a real threat to our democracy. And I would have a Four Seasons landscaping photo behind me, but I will just conclude without it, but with its idea in mind. Thank you.
Chris, you're muted.
Sorry, let's move quickly on to Braden Cormack and his paper, Cases, a Defeasible Form, Montaigne and Hart.
Thank you, Chris. I want also to thank Berkeley and the English department and Brian for the invitation to be here with you all. I am very, very grateful to be here, and I've enjoyed the conversation so far. So this talk comes from a book I've been writing about examples, about how early modern writers thought about them and with them. And my question very generally in the book is not really how examples are used, but what examples are, as a something in experience that gets transformed into a discursive thing, including sometimes a discursive life. A poor cousin in the family of thought, examples are always, in one way or another, mere examples. On the one hand, examples may be said to be too particular, too close to experience, too packed with details impertinent to their application in the corner of experience where they are supposed to help. And on the other hand, examples may be said to be too general, too far from experience, too little individual. insofar as the work to make the event into an example has removed it from its own singularity, which is the only place it has anything like the meaning it needs in order to be helpful. Case thinking, including at law, is tricky because if all that counts is the general rule, the case turns out not to have been doing any of the real work. And if the particulars do matter, the question is always going to be some version of how to get an analogy across an irreducible circumstantial difference. The last of the essays in Montaigne's 3 volumes of experience is concerned with the epistemological character of the analogical application of one thing to another. He begins the essay by identifying its scope. There is no desire more natural than the desire for knowledge. We try all the ways that can lead us to it. When reason fails us, we use experience, which is to say we use examples drawn from experience. It's important here that the exemplary thinking that Montaigne's essay is everywhere concerned with, and which leads him notoriously to eschew traditional examples from antiquity in favor of whatever examples are at hand, in his village, in his household, in himself, in his ailing body, that thinking is here posited as coming to have force where a certain kind of deductive reason has failed. Given reason's failure, the essay starts by asking, how might this other kind of thinking proceed? That framing statement is useful for hearing the force, a few sentences later, of Montaigne's turn to law, where somewhat curiously, he mixes cases and laws as if the two categories presented the same problem. What have our legislators gained, he says, by selecting 100,000 particular cases and actions and applying 100,000 laws to them? This number bears no proportion to the infinite diversity of human actions. Multiplication of our imaginary cases will never equal the variety of the real examples. Add to them 100 times as many more, and still no future event will be found to correspond so exactly to any one of all the many thousands of selected and recorded events that there will not remain some circumstance, some difference that will require separate consideration in forming a judgment. There is little relation between our actions, which are in perpetual mutation, and fixed and immutable laws. Now, as you hear, there's a double target here, although I think this hasn't always been emphasized, as Montaigne moves between 2 aspects of legal reasoning, one involving fixed and immutable laws, and one involving experience, example, case thinking. That fixed and immutable laws should not encompass human diversity, the diversity of circumstance, is hardly surprising. It's a commonplace, in fact, about the force of legal reason and legal form in the face of contingency. The second failure, that of the future event to correspond to another event, even one within an impossibly large set, is also a failure in the face of contingency, but it is not the same failure, since the event is not a law, but an example that is insufficiently tight in its fit with the future to do what it is supposed to do. Now, noticing this doubleness, we might notice too that Montaigne's point about the immutable law is, strictly speaking, not quite within the essay's scope, since that kind of reasoning was left behind in the essay's first sentences. And yet, as we read the passage, the 2 failures remain very hard to extricate from one another. And my hypothesis is that in a submerged comparison, Montaigne is exactly approximating the 2 failures as a way to notice that the problem with exemplary thinking is not the example per se, but rather the method, that in its search for the exact correspondence, as impossible and ideal as the fixed universal law, treats example as if it were rule, as if the point of the example were to be immutable in that way that immutable laws are. But so construed, example just gives us another name to the deductive reason dismissed in the first sentence. So what Montaigne is after then is a different example, a different way of transacting experience that might escape this default adequation of the example to the thing it is posited as adjusting. What sort of thing might a reformed example be? I'm going to suggest that a category developed by HLA Hart in a paper from the 1940s, late 1940s, can differently applied help us see something about the nature of the epistemological work that case thinking does. Nothing Hart says solves the problem of examples' peculiar vulnerabilities, but it does change a view onto them. In 1948, Hart delivered at the Aristotelian Society a paper, The Ascription of Responsibility and Rights, as a legal contribution to analytic philosophy and specifically theories of intentional action. The argument, although widely read through the 1960s, then fell into relative obscurity, not least because Hart declined to reprint it in a 1968 collection, and in a note there effectively disowned the argument in light of criticism levied against it, especially by Peter Geach and my late colleague, George Pitcher. Neither of those philosophers quite got what Hart is up to. For our purposes today, I'm just going to offer a brief description of the essay as a way to suggest the value of the categories it produces, even beyond Hart's extremely ambitious argument. Hart sets out to show that sentences of the very general form, "he did it," have mistakenly been taken to be primarily descriptive, when in fact they are, in his phrasing, ascriptive, their function being quite literally to ascribe responsibility for actions. He's also thinking with sentences where something like a right is ascribed. Now, he's quite clear that what he has in view is not just blameworthy actions of the kind that regularly come up in court, where responsibility is obviously at issue, but all actions. And this is certainly an odd claim to make about so innocuous a thing as, say, playing the piano, that's Pitcher's example, or crossing the street. But Hart's point here, in fact, will turn out to be quite modest, which is just to name with the ascriptive what it is for an action to be an action. The ascriptive pertains to the extent that the action is one. This first claim about ascription cannot be understood outside the second and complementary part of the thesis, which is that insofar as it is ascriptive, the action sentence is defeasible. Concisely put, the double thesis is that action is an ascriptive and defeasible concept. Defeasibility is a term that Hart takes from land law. A legal interest in land is held to be defeasible insofar as it is subject to termination in a number of different contingencies, but remains intact if no such contingencies mature. But he develops the concept of defeasibility not in relation to land, but in relation to contract and criminal law, his chief example in the latter being homicide. Both contract and homicide, he says, are defeasible concepts in the sense that each carries a kind of unless in it. An unless that he understands in the adversarial context of the courtroom as continuous with the list of defenses or exceptions that would counter an otherwise valid claim in contract, or that meet the criminal charge so as to reduce or exclude liability. Now, such defenses can take various forms, but the ones he focuses on, since his goal is to theorize action and the mental component in action, are those involving a mental component around the presence or absence of voluntariness of consent and the presence or absence of mens rea, the absence of these being sufficient to defeat the contract or criminal charge. Now, the remarkable point that Hart emphasizes repeatedly, and in fact, this he remained committed to in his later writing, although he never returned to the argument about action, is that for such concepts as these, no adequate characterization of the legal concept can be made without reference to these extremely heterogeneous defenses and the manner in which they respectively serve to defeat or weaken the claims. It will therefore be a mistake, he says, to say of contract that it belongs positively to contract, that the consent be true, full, and free, since that apparently helpful positive statement will be accurate only if it is treated as a reference to the defenses with which claims in contract may be weakened or met, and to the fact that defenses such as undue influence or coercion are admitted. Similarly, in homicide, the fact that accident, coercion, duress, provocation, and so on are admitted as reducing liability does not mean positively that there is a single element, intention, that is required for criminal responsibility, but that certain defenses, rather, are allowed. Now, Hart is much interested here in the fact that as a theoretical move in legal writing, but also as just part of a more ordinary way of talking, we often speak as if it were possible to impose a unity upon the defenses and exceptions, implying that defenses such as mens non rea are admitted as evidence of the absence of elements, intention, foresight, voluntariness, that are universally required as necessary conditions of responsibility. But he says, this is misleading because what the theorist misrepresents as evidence negativing the presence of the necessary mental elements are in fact multiple criteria defeating the allegation of responsibility. And he adds wryly that although it is certainly possible to represent the admission of these defenses as showing that there is a single mental element required as necessary mental condition of full liability, the determination of what voluntariness, foresight, intention are as categories will require one to refer back to the various defenses, which means that these general words assume merely the status of the convenient but misleading summaries expressing the absence of all the various conditions which eliminate responsibility. I'm coming to the end. All kind of things positively seem to work rather, this is his point, through an ongoing negative adjustment. And Hart's target is the congealment of thought that allows in his concepts that slippage, allows the concept to swallow as positive the zone of negativity around the concept. A negativity, and I want to stress this, that irreducibly constitutes the concept and makes it what it is. Hart's target is thus the ideal description, the comprehensive description. And that being so, we can hear now why the ascription is something like the complement to the defeasible, two aspects of the same attack on a misleading logical ideal that concepts must be capable of being defined or described through a set of necessary conditions. Now, as Hart pursues his argument, he suggests that action generally is defeasible and ascriptive, rather than descriptive, insofar as any statement about the action can be negatived through challenges like the legal ones we have been considering. No, I didn't open my umbrella, the wind took it up. And Hart points out that the positive looking words, intention, etc., which we use to define action qua action, are only understood when interpreted in the light of the challenges and not vice versa. When we ascribe an action to a person, he says, the question whether a psychological event occurred does not come up in this suggested positive form, but in the form of an enquiry as whether any of the extenuating defenses or challenges cover the case. We notice something that looks like an action, and if on consideration we find it wasn't one, we withdraw the judgment. And it is to be noted here, and this is Hart's final remark on his theory, and it's a really interesting point, I think. If we do withdraw the judgment, we do not do so because of an error of description, not because of a qualification that would introduce the negative space around the action into the action as a quality of the action, but instead we adjust it as an adjustment of the ascription. Now, in conclusion, my suggestion is that we think of examples, including the legal examples we call the case, not in relation to a description that subtends some class belonging. This is a clear source of the difficulties for theorists of the case. Instead, might we say that the case is a defeasible ascription, in the sense that the example literally makes a claim, the claim we call analogy, and that the example is not open to a comprehensive description, but is in fact constituted, like Hart's categories, by a zone of negativity that belongs to it and vexes its use, but not, I think, its ontology. Now, Montaigne represents as absurd the absurd notion that for an example to be an example, it must be comprehensively similar. The description of such a thing is a patent impossibility. But the hint there is that the problem that plagues exemplary or case thinking is not to have noticed that the example's claim on experience is nested irreducibly in the zone that might defeat it. In conclusion, I don't think that the application of Hart's principle resolves the problem with examples that Montaigne engages, but it does shift our view. And it does shift it towards judgment, but a judgment that is as restless as the thing it is engaging. And here, in a final quote, is a gesture towards that part of the argument, and it's what Montaigne says about his own mind. And it restates the problem of difference and variability, infinite in human experience, but it also begins to characterize the judgment that might allow thinking to continue. What is remarked as rare in Perseus, king of Macedonia, that his mind, sticking to no one condition, kept wandering through every type of life and portraying such a flighty and erratic character that neither he nor anyone else knew what kind of man he was, that seems to me to fit nearly everybody. It's a disaster in Montaigne's view to close off any aspect of experience since it's not clear in advance where the example you need will come from. But the openness of the essayist's rangy thinking, which in this passage he makes available to everybody, bespeaks a freedom consonant not only with the infinite number of examples we might encounter, but with the very shape of the example, as it takes the unpredictable and, I think, defeasible journey that makes it itself. Thank you.
Thank you, Braden. Finally, we have Rebecca Taschnet, Transformative Works and Transformative Workers.
So I'm going to try and share my screen. Hopefully that worked. It's a little hard for me to tell. Can you see a couple of symbols on your screen? Excellent, thank you so much. Julie Stone Peters' presentation really resonated with me, and I hope you will excuse some of what may be my preaching to the converted and use of slogans. Compared to the other panelists, my work actually offers another take. Maybe we've worked our way up to a pun in terms of the legal uses of fiction. So I work with and was a co-founder of a nonprofit, the Organization for Transformative Works, known as the OTW. It doesn't have a single paid employee, has a budget of under $400,000 per year, and operates a website, the Archive of Our Own, or AO3, for non-commercial fan works. Currently has over 4 million works from over 1 million registered users. So these millions of works received 1.12 billion page views per month as of early this year. So you can see that it's our daily traffic. And you can see the comments and site traffic, and you can see actually we had a really huge spike with the pandemic. So online fandom is an important means that people have to connect with other people in a time of physical distancing. So there are a number of features that I think are unique. I'm going to talk about the organization of the site, and then the sort of legal structure of the arguments that we make around fan fiction, which has always existed since it was recognized as a thing, has always existed in dialogue with a discourse about copyright and fair use. Before copyright, there wasn't fan fiction, there was just people writing things. So to distinguish the fan from the professional actually required the creation of copyright. So some of us trace our origins to, Homer and Shakespeare, but there are real discontinuities because of the role that copyright plays in the modern expressive environment. So before talking about that, though, I want to share a little bit of what people do with the site. So people post fan works on the site. It's easiest to post a text work, but in the long term, we would like to be able to host ourselves art and video, and right now people can embed them. And there are a number of things that you can do to signal what it is that you have. So you can see I've put up the categories that we have. We ask you to tell what fandom it is, and then there are a bunch of different things that are mostly all optional. You can use tags either so people will know what the work has, and people who are looking at it can use the tags either to say, oh, I definitely want that, or I definitely don't want that. So we have search options either way. There are a few mandatory warnings, but the creator can always choose, I don't want to tell you. That actually satisfies their obligation in terms of mandatory warnings. This turns into, on the back end, folksonomy. So people can type in whatever they want. And in the back end, there are volunteer tag wranglers who will link related tags together. So it turns out if you misspell Harry Potter, we actually won't correct your spelling, but on the back end, we'll correct it and make it a synonym with the proper spelling. And this is also true with translations into different languages. My favorite example is that the tag, "the strangled cries of lawyers in love," has been made a synonym of the larger tag, "lawyers." So in the bottom right there, you have an exemplary tag cloud of different tags people have used in their complete freedom to do so. And this kind of organization where people have a lot of control over how they present stuff, and we do some minimal work on the back end to help other people find things, is an example of, I think, feminist interface design. We aren't interested in telling you what's the most popular thing on the site. You can search by popularity, but you don't have to. And we aren't interested in keeping you on the site to show you ads. So this really is a very creator-focused approach, and for the convenience of creators, and secondarily for the convenience of audiences. So why do we do this? We do it because we believe in the importance of transformative fandom. So here I think about the fact that feminist and critical race theorists cautioned that the critique of rights could be dangerous, deployed in a context when marginalized groups were finally gaining the ability to use rights claims to demand an end to their subordination. So something similar is at least at risk here. The critique of unitary authorship, that there's no such thing as a singular author. Everybody always contributes to discourse that has already, out of things that have already been said. This is both correct and extremely difficult to convey to policymakers who really like meeting famous artists. So one of our techniques is to claim authorship for the rest of us, showing how fan creators do work that can be indistinguishable in its formal characteristics, in its internal meanings, both to the creator and the audience, and in its external reception from the work of creators who don't identify as fans. And in particular, we actually do a fair amount of advocacy work, deploying literature in law. And one of the examples that I want to talk about is that the National Telecommunications and Information Administration did a green paper on user-generated content and how the law should regulate it. And we used the testimony of hundreds of fans to explain the importance of what the government called user-generated content, what our users call art. Fic, vids, other creative works. And we heard again and again from our creators that fandom and making and consuming fan works saved their lives. They were quite literal, and in some cases, heartbreakingly graphic about it. Why fandom? This is a lovely cartoon from a fan explaining, I think, that you get in fandom, you can customize a work for what you want out of it. The fan does not have to accept what's presented from a mainstream cultural work. They can actually take their interpretation of the text and create a bunch of other texts with it, and find people who either, even if they don't share in that interpretation, are at least interested in that interpretation and interested in having you customize your own experience. So this cartoon has a bunch of references to various fandom tropes. My favorite little detail, you'll note that in the middle column on the third panel, the pig that is supervising the fiction about pining is actually eating little pine tree cookies. So it's that level of detail that transformational fandom sort of lets people indulge in. And it's very important often to find a community of people who think your thoughts and creations are important. For many of our users, it's the first time somebody has thought that what they had to say was actually important. I always found this cartoon to be extremely useful there. For some creators, reimagining well-known characters as Black instead of white, or as disabled, or as trans, or non-binary, or asexual, or many other features. Those are important ways of claiming space for yourself as a creator, and for claiming space for people like you. Now, in our presentation to the NTIA, we also include the accounts of people who articulate more instrumental reasons for making transformative works and participating in transformative fandom, though often the instrumental is tightly linked with the effective. So people learn new languages, right? They learn how to make art, they learn how to make videos, they learn how to write. Many tell us they found educational majors or even careers from the things they learned about themselves in fandom. One of the most affecting stories came from a teacher who explained how an Asian American student had been failing English until she was allowed to write Harry Potter stories with characters who looked like her, what we would call a self-insert, or even a Mary Sue, and how she went from a struggling student to an outstanding student with a university career. And I want to emphasize, our deployment of these claims about the rational, productive benefits of fandom is itself instrumental. It is an attempt to persuade policymakers who aren't interested in or even able to count non-economic values of self-expression as having meaning, but they are tightly linked. I think of this as redeploying the concept of the romantic author into the concept of the romance author. The ultimate goal is to present the fan creator as someone worthy of respect. In other words, when I speak to Congress, I'm trying to speak in defense of teenage girls who are overrepresented in fandom. And in some respects, I'm defending the teenage girl I once was. And teenage girls really don't get enough cultural defense. And defending fandom is part of that. So I should say a couple of words actually about our name. And that will be kind of my big final point, which is that deploying law in literature is also an intervention into fandom spaces. The concept of transformative works and the name of the Organization for Transformative Works, comes from the US Supreme Court case of Campbell versus Acuff Rose, which found that works that transform the original with new purpose, meaning, or message are likely to be fair use, and thus likely not to require the permission of the original copyright owner. And there's some interesting research suggesting that fans worldwide are picking up on the US concept of fair use, even though most countries around the world don't have fair use. Instead, they have more limited doctrines known as fair dealing. And it seems likely that the Archive of Our Own, which does have worldwide distribution, is part of the dissemination of the concept. We also use transformative to define what it is that we do, trying to make that a very big tent. If you have an intervention into that you think of as Fanish, then we think of it as Fanish too in general. The other word I think that's worth emphasizing is works. So works has a bunch of different meanings here. In one sense, it calls out to creation as a process and not just a product. Work is work. Work takes work. It is the instantiation of work that has been done. It is true and that emphasizing works, the nouns, may de-emphasize workers. And there is a related and very important question about non-commerciality in fandom. How important is non-commerciality? The OTW is deliberately non-commercial. There are more radical versions, people saying that people should be able to get paid in various ways. Keeping fandom non-commercial does keep a feminized space from getting the kinds of economic rewards available in more masculinized spaces, and that is something worth talking about. I just will end very quickly by saying that, because we have content from all over and of all kinds, we have also become involved in debates over content moderation. So fandom has some awful things in it because fans are people. People do awful things as well as great ones. And it is possible that a non-commercial space may have some lessons for more commercial platforms. The key here is we don't want you to spend any longer on the platform than you want to spend. We have no algorithm prompting outrage or prompting discovery of more extreme content. And that, I think, can be quite important. And we should think about that when we think about, what kind of future do we want from our online experiences. So I hope we can, if you have questions, please ask them.
Thank you very much. As Brian has asked all of the moderators to try to ask global questions, I want to share a thought that came to me actually as I was listening to the presentations, which may strike you as a little bizarre, but the presentations remind me of Mary Douglas's definition of dirt, which is that it's matter out of place. And by that I mean law as a technical discourse defines itself, prides itself on its sort of elaborate separations, its barriers, its boundaries, which carefully distinguish it from other kinds of discourse. And yet, what we've just heard are 4 presentations which point very much to the porosity of those limits and boundaries, and in fact, very much, I think, in the spirit of Peter Goodrich's riff, citing Julie, on jurist literature this morning. Because it strikes me that the presentations show the dependence, if law is to be creative, if it is to move from where it is to where it desires to be, where lawyers wish to pick up law from where it sits and to extend it, to move it either jurisdictionally or spatially or intellectually or geographically, then they are constantly referring from beyond its own technicalities to other forms of discourse. For me, for example, in Susanna's account of the trial of Charles Huntington and the invocation of the kind of the creation of the allegory to Hamlet within the trial, this allegorization to Hamlet serves a very specific purpose that could perhaps not have been undertaken other than by using material from outside the formal sphere of the technicality of fraud and its defenses. The thing that I found most interesting actually in the paper was not the general question about the relationship between sort of fiction and fraud and con man and capitalist, but rather the action of the lawyers themselves. They are taking a delight in presenting a knowledge from outside. You say that lawyers write about Shakespeare, prominently write about Shakespeare in the 19th century United States. There's this kind of hint of the orgy of Rabelasian professional cultural display that Angela Fernandez invokes so enthusiastically in her lovely book on Pearson against Post. This is the bar at work, showing off, engaging in the manly professional literary culture of its own sort of interactions. And in the process, they are moving law. They're moving it into places where it previously was not, and using these distinct discourses outside the realm of technicality to do that. I have the feeling, although I have the feeling that Braden is telling us something similar in a very precise way. This is a paper almost entirely about the precision of forms of legal reasoning and legal argumentation, and yet the movements that Hart is allowing to take place, I intuit, are occurring because Hart is allowing himself to think outside the, as it were, the technicalities, outside the box, or at least he's saying on what terms the technicalities can be cautiously expanded, on what terms the technicalities can be moved. And to move the technicality, one has to move outside the technicality. Simon does the same thing. I mean, fictions, you know, I teach Henry Maine. Fictions are the way the common law moves in Henry Maine's ancient law. It's one of the three major, and indeed, if you say that, you know, you don't really get legislation until the 19th century, I mean, I'm exaggerating, but if you say you don't really get legislation until the 19th century, then fictions become a really important way for common law reasoning to create modes of extension. And finally, Rebecca just has given us this wonderful account, it seems to me, complete with graphs of spikes and so on that demonstrate a kind of a totally creative interface between technicality and forms of creation in an organization which is moving, which is using legality, or which is moving legality in a way I think that is analogous to the other three. So, I mean, I don't actually have a global question. I have, as you've just heard, a set of impressions. And perhaps those impressions are worthy of your comment, or perhaps they're not. But I leave to you to decide whether you wish to do so. But if you do wish to do so, I suggest we move in the order of presenters, which would give the first opportunity to you, Susanna.
I'm still ruminating on the sort of initial idea of dirt as matter out of place, and trying to think about that in relationship to law. And as I am thinking out loud, I think I'm going to invite my other panelists to possibly respond while I'm still thinking. That was a bit of a punt.
I'll say something. So I thought, Chris, that the way you bring the four papers together corresponds very much to what I noticed. In various ways, we're all speaking about the work of imagination to create something that is that exceeds its own boundaries or expands its scope. In relation to, I mean, and I just want to say, I have the other three presentations are just fantastic. I have questions, and I'm not going to bring them up now, but I will. I hope be able to speak with you later. I thought they were tremendous papers. And with extremely surprising connections among all four of them. In relation to Hart, I think your account of what I find so invigorating about the essay, in spite of his disavowal of it, is that he is doing a double renovation. He's renovated, and I think this has something to do with why the paper basically failed. I think no one in philosophy wanted to hear it. And I think that essentially the philosophical community found ways to contain it. And in relation to law, there wasn't quite a place. But in fact, he's working in a double direction. And I should say, just as a biographical matter, at the time he gave the paper, he was appointed in a philosophy faculty and moved more fully into a legal position in the early 50s. Yes, the renovation of intentional action, which is the nominal goal of the paper, and I think it's quite remarkable. Whether or not it absolutely succeeds, it offers an extremely, extremely interesting view onto that. Happens only because he's offering an equally imaginative renovation of the legal categories, and that's because he's thinking about them reciprocally, and opening up in the notion of the defeasible, which is really the takeaway concept from the paper. Opening up in the notion of the defeasible those slightly sedimented categories to spaces of not just of technical correction in the adversarial context of the courtroom, but actually to an entirely different conceptualization of what the concept is. And that seems to me continuous with the work of imagination that you're pointing to and that we're hearing about in the other papers.
Thanks, Chris. That was wonderful. And so implicit in what you say is also that discourses about the law, efforts to try to understand the law, are themselves likely to recapitulate precisely those same movements. And it's wonderful that you give the example of Maine, because so I obviously wasn't able to get to that in the paper, but so Maine says that there are three modes of legal change: fictions, statutes, and equity. And he very strongly implies that courts shouldn't be fooling around with fictions when equity is the proper vehicle by which to affect such change. And what I think is wonderful is the way in which Maine's own account is worthy of being understood according to the same problems, the same problematics, and the same efforts to shore up a correct way of licensing legal change, and yet inevitably leaves itself open to exactly the same kind of analysis. So I really appreciate that. Thanks so much.
So I'll just say, I really appreciate the dirt reference, right? So I think a lot about the abject because of the ways that women's fiction, fan fiction are often dismissed as somehow unworthy. To me, this connects up with Joanna Russ's, how to suppress women's writing, right? So, and I have to say, my project is in many ways, it's a classical liberal legal project saying, no, actually, this isn't dirt, right? Actually, this, and I'm certainly aware of and willing to talk about the ways that there are some contradictions there, but that's how you change things. You convince people that stuff they thought didn't belong does belong.
And I'll just simply now return to say that there's a lot that I could say about the kind of orgy idea, the sort of masculine performance of kind of virtuosity across multiple disciplinary divides that extend far beyond law. I think that's certainly true of the way that these lawyers tangled with Shakespeare. And it is, to me, very striking that lawyers were so centrally involved among the literary critics in the 19th century. I mean, Julian Verplanck is one of the apparently most respected commentators of the day. And I would add, just to put another gender twist on it, there's a very famous episode. There's a debate, of course, about the originality of Shakespeare. Was it really Shakespeare, after all, that wrote them? And this is sort of connected up with higher criticism and connection with the Bible in the same period. So there's lots of things at stake in terms of creativity and originality that are floating around in these conversations about Hamlet. And the famous claim that Francis Bacon is in fact the author is made by a female literary critic who is said to go mad eventually. So it all sort of then circles back to madness at the end, as most of my work ultimately does. So thank you for the comment, though.
And I should mention, of course, the Archive of Our Own is a deliberate play on Virginia Woolf's A Room of Our Own to connect back to Shakespeare's sister.
I'm not sure if Brian is with us at the moment. Perhaps Julie has a question which she has written addressed to you, Susanna. We often think of the 19th century as the era in which legal positivism took hold, that the legal system should be autonomous, untouched by morality, emotion, oratory, etc. Can you comment on the relationship between the rise of positivism and the rising cultural centrality of courtroom spectacle and celebrity trial at the same time?
Yes, briefly, I guess I would say that I think that's to some extent there's a clear way in which I'm thinking of Robert Ferguson's law and literature configuration. And I've wrestled with that as I've worked on this material because it doesn't seem to ring true as much as his sort of way of characterizing the split by, he sort of suggests the antebellum period is a period in which you still see a lot of permeation between sort of law and literature, and you have lawyer writers, and increasingly the professional way, the way that is to sort of put those things aside. That's for your leisure time, if at all, and you're not someone who engages in sort of imaginative writing of any sort. That's not a part of the professional world that you should be engaging in. And there is something to that, and certainly with the rise of professional associations, one can see some degree of that happening for sure. But the allusions to Shakespeare continue, those kinds of moves in trials continue to sort of operate in maybe not exactly the same way, but certainly in a way that cuts against the sort of rendering of positivism that you have offered. And one possibility, of course, is that it is really increasingly just a feature of these kinds of sensational trials. It's just a certain kind of lawyer and a certain kind of situation that makes that the appropriate way of being in the courtroom, and that there are lots of instances and types of trials that don't admit of that kind of behavior or way of being. And I would say that since I focus so centrally on insanity trials, I would say it is a feature of insanity trials. And one of the things that is kind of striking about the insanity plea is how constant the association between insanity and fraud is. Like the insanity dodge just almost rolls off the lips, and the idea that you're doing anything but something desperate when you make an insanity plea, and that is in some ways kind of a made up defense, I think sort of kind of shadows its use. And so the theatricality that we're seeing in the kinds of cases that I look at may be a feature of the fact that this is a kind of unusual sort of trial.
Great. So we've actually reached the end of our time for this panel. This has been just so exciting. Thank you all. We have one more panel to go that will happen in 15 minutes at 3:30. So thank you again to everyone. This was wonderful. So at 3:30 West Coast time, 15 minutes from now, our last panel will commence.